Okay, let's get started on the second panel here. The second panel concerns legal liabilities, cooperating with government, and cyber insurance. I wanted first to introduce the panelists and thank them very much for coming and sharing their insights and wisdom with us. Introducing it farthest from me on the left is Michelle Vissar, who's a partner at Ropes & Gray. Next to her is Teresa Shea, who's a former director of signals intelligence at the NSA and now executive vice president and director of cyber reboot in QTEL. Next to her is Lauri Floresca, who is senior vice president of corporate and executive protections at the insurance broker Woodruff Sawyer. And next to me is Malcolm M.K. Palmore, who's the assistant special agent in charge of the cyber branch of the FBI in San Francisco. These are three slightly different areas, although they're obviously related, that we will discuss. The way I sort of put them together is a little bit by the theme that I introduced in my earlier remarks, which is that we all operate very much in a society and an economy where these breaches affect more than the direct victims of the breach. Moreover, the earlier panel, which was absolutely terrific, talked about the many ways in which there are what economists call externalities. In other words, I have my camera, it may make me vulnerable, but it also makes the rest of you vulnerable in the sense that it can be part of a large botnet that has profound effects on you. And when we think about externalities, both positive and negative externalities, we think of the way that society has adapted in order to address those externalities. So, and one of them is clearly the legal system. Right? And legal liabilities are a way of moving around risks and moving around losses in order to create the right incentives. So it's interesting to think about the scheme of legal liabilities and of regulation that we have, not just because it's of concern to you and compliance and the prospect of legal liability, but it also is of concern to society as a whole to see, is it being set in a way that sets incentives to optimize incentives or to optimize a risk management not only within an enterprise, but also across the economy. I mean, you could imagine, for instance, if with a Dyn hack, your business or one's business suffered losses because customers weren't able to come to the website. That's a significant loss. Well, whose fault was it, or where would you imagine that the legal system might, it might not, but it might pass on the loss. It might pass on the loss over to my security camera that I have that was actually co-opted in order to conduct the attack, and I could then transfer the loss over potentially through a legal action to the supplier of the camera, and so on down the line. So these are the things that the legal system has to take into account in assigning legal liability, whether it's through fines or civil actions and so on. But there are also other ways of dealing with the externalities. One is obviously government. And so the relationship between government and private actors is important here. And finally, through the market, especially insurance is a way also of passing along risks or sharing risks, which is interesting in dealing. So that's how I see the coherence between the three topics. Because they're fairly specialized, because, for instance, the scheme of legal liabilities and regulatory liabilities and civil liabilities is something that is fairly specialized, and we thought it would be a good idea if this panel spent some time, limited time before we get to discussion, to sort of lay out the framework. Lay out some basic information of what the key facts are and key parameters are in these three areas. So what I'd like to do is start off by asking Michelle if she could just spend a little bit of time laying out the framework and the environment for legal liabilities, criminal, regulatory, as well as civil. Thanks, Michelle.
Thanks. So we're going to attempt to do in about 10 minutes or so what you often have full days of conference doing and talking about what the overall scheme of liability is here. Starting out on the private action side, one of the things that I think anyone that watches the news might see is anytime that you have a large-scale data security breach, it's nearly inevitable that you'll have consumer class actions filed, oftentimes, within 24 hours after the incident has been announced. In that realm, the customary themes are that the company that's been breached has done one of three things. One, inadequately protected the data, thereby allowing the breach to happen. Two, it deceived its customers or other entities it deals with regarding the level of security that it had, and that misleading statement was revealed through the breach. Or three, it may have waited too long to notify customers or the impacted individuals as to what happened. The general trend that we're seeing here is that these cases are either dismissed early or they're settled. One of the main reasons that they're dismissed early, and this might show my defense side bent in this whole debate as well, is that the fact of the matter is that in many of these cases, the ultimate consumers whose information may have been accessed aren't really injured. A good example is in some of these payment card breaches. As many of you know, you see these ads from Visa talking about zero liability, which means that you yourself, as the card carrier, aren't covering the costs. Similarly, when other information is accessed, it's difficult to show that a consumer was actually hurt. And what this means from a legal perspective is that oftentimes when consumers bring these cases, there's a huge debate right now about whether they actually have standing to be in court, whether they've shown a sufficient injury, either to have Article 3 standing or just to actually state a claim. Currently, there's a real debate in the courts on this, and unfortunately, for the defense side, there's been a spate of recent decisions, though, that are actually showing that courts are more willing to let these cases go. And in that situation, we do typically see, if it's not dismissed early, the case basically settles. So the unfortunate fact of the matter is because we aren't having fully litigated cases, there's not really an established body of law as to what's required from companies in the private action setting. Just a little bit of background, too. As far as settlement dollars go, oftentimes the cost of the settlement isn't viewed by companies as being a huge cost. For large breaches, more than 1 million records is typically less than $1 per record is what the settlement is. So that can still add up, but for some of these larger companies, that specific cost isn't viewed as largely material in the scheme of things. Overall reputational damage and other costs associated with the breach, though, can still be very large. One recent trend here, too, to highlight is that we are seeing a shift that these cases are moving away from just being based on the most sensitive data, so payment card information, social security information, and that they are being brought based on what typically has been considered less sensitive information, so potentially just names and passwords and email addresses might still result in a class action. We're also seeing more cases in the employment context. Moving on, besides consumer class actions, in any data breach that involves payment card information, there's also a risk of a class action brought by issuing banks. Back in the day, these were fairly uncommon and reserved for really just the largest of the large breaches. Recently, though, in part potentially due to some success that plaintiffs have had, we are seeing them associated with smaller breaches as well. Again, the same customary themes in terms of what the allegations involve, a general failure to adequately secure the data, and then also potentially deceptive statements, but those claims tend to get dismissed early. Similar to the consumer side, we haven't had examples of cases that have been fully litigated. So again, the actual standards are unclear, but it's a risk that companies face. On the payment card side, too, one legal liability to keep in mind that doesn't often get a lot of press, but can actually result in the greatest exposure for companies is the card brand assessment regime. And what this is that the major card brands, such as Visa, MasterCard, Amex, and Discover, they all have their set of rules or regulations which, through a contractual regime, they essentially force onto retailers. What happens is the brand has a contract with an acquiring bank, which in turn has a contract with the retailer. And pursuant to those contracts, merchants or anyone that accepts credit card information has an obligation to comply with the payment card information data security standard. And the rules provide that if they don't, and a breach happens, and the breach is caused by that failure, certain costs can be then shifted to the merchant through the acquiring bank and that system of contracts. And there, as I mentioned earlier, whereas in the consumer context, you often see settlements less than $1 per record. In this context, and amounts can vary, but assessments themselves actually come in, we've seen assessments that are greater than $10 per record, so that can add up very, very quickly. In these cases, there are defenses, and that can often result in the amounts being negotiated down, but again, there's very little litigation in this context as well, but it's definitely a legal liability that can be very significant for companies. Two other types of private actions that I'll touch on briefly, would actually sometimes skip, but given this crowd thought it was good to mention, are derivative actions and securities actions. So the derivative side, as many of you know, these are cases that are brought against directors and officers based on allegations that they breached their fiduciary duties in some respects. And in the data breach context, the allegation is typically that they failed in their oversight duties, and had they not done so, that could have prevented the incident from happening. For a number of reasons, these cases have been very unsuccessful so far, which might explain why there are still relatively few of them. We have seen them recently, though, as recent as the Target data breach from a couple of years ago. That case, like many of the others, was just dismissed. And so, in general, it seems like that's going to be a very tough case for plaintiffs to make, but we do see them still trying, and I think it's still relevant to consider because, for one thing, directors and officers never like to get sued. The other thing, of course, is that even when they do get dismissed, it can be costly just to work through the process, and it can be time-consuming. In Target, for example, it was dismissed, but only after a 21-month special litigation committee investigation that took up a lot of resources and time of people that obviously would be preferring to spend their time elsewhere. The other category to briefly touch on is shareholder litigation. Again, this has been very uncommon, but you can foresee the factual situation where it happens, and in the cases where it's been brought, the theory is that company officers or the company itself made misleading statements about the security controls they had in place or the related risks they faced, and that when the breach happened, that effectively revealed that these statements were in fact not accurate. The stock price dropped. Again, the cases that have been brought to date have all been dismissed very early on because plaintiffs have had a hard time establishing the required elements of actually having an untrue statement and then the level of scienter necessary to establish that claim. So moving on now to the regulatory side of the legal liability landscape. Here again, I think should be expected that anytime there's a widely publicized breach, there will be some sort of regulatory investigation that follows. One of probably the main regulator that people think about in this space on the federal side is the FTC. They've been investigating in the cybersecurity space and bringing enforcement actions now for more than 10 years. The theories that they bring in many ways are largely similar to what you see on the consumer side, and they're doing so under the FTC Act, Section 5, which gives them the power to investigate both unfair and deceptive conduct. So on the unfair side, their theory is essentially, again, that a company had unreasonable controls in place, and that because of that, it resulted in substantial consumer injury that wasn't outweighed by countervailing benefits, which effectively means that the company could have implemented these controls at a cost that was less than the risk ultimately borne by the consumers and the injury that happened. The other side of the coin is the deceptiveness theory, and this one is actually much easier for the FTC to prove because the substantial consumer injury requirement isn't present. And so I think the guidance for companies to think about is in many cases, the FTC might shy away from an unfairness claim because it's tough to prove. But if they can look at your public statements and you are being too aggressive on touting your information security controls, that's a very easy case for them. And in those situations, they're much more likely to be aggressive in pursuing a case. The FTC itself, one of the things in terms of their enforcement power is they don't have the ability to impose penalties. So they're limited to injunctive relief, But I think if you ask any company that's been subject to one of these consent decrees, in many ways they would say, looking back, we would have preferred just to have paid a large fine and been done with it, because these consent decrees last for 20 years, they require biennial assessments, and they're very burdensome. And often they go above and beyond just protecting the type of information that was originally breached and require very broad obligations for all personal information, which is defined very, very broadly. The counterpart to the FTC on the state side, of course, is the AGs. And in many ways, their theories of liability are similar. The distinctions, though, are that they also have, some of them, statutes that specifically require reasonable security, and they have the notification statutes. So these are the statutes that require companies, after they've figured out that they have an incident, to report them both to consumers and in many cases to the AGs, which, of course, ultimately results in, once the AG receives the notice, they turn around and investigate the company. The other major difference is that the AGs do have penalty power. And here, again, given the lack of litigation that's actually happened, it's one of the great unknowns as to how far that goes. And the reason for that is that the penalties are stated on a per violation basis. So, excuse me, as a defense lawyer, I would say that a failure to have reasonable data security is a single failure. On the AG side, they would say every single record that you let out the door is a separate violation. And when you multiply that by the 5,000 per violation that they could get, it's a massive swing in exposure, which is one of the reasons, again, why cases either the investigations dropped or they settle, because there would be a lot of risk in continuing the case. So again, we haven't seen examples of fully litigated actions there. So the FTC and the AGs are often viewed as the two main regulators. On the federal side, there's other groups that do regulate in this space. Many of you, of course, have heard of HIPAA. This is specific to PHI, health information. And there, of course, this just covers covered entities. So that would be, healthcare providers, healthcare plans, and their business associates. The HIPAA rules are slightly different than many of the other regulatory regimes in that there are some more specific requirements to follow. They do have penalty power as well as injunctive power, and recently have been fairly aggressive in the remedies they've sought, and have entered settlements that are, 7 digits are becoming more and more common, with some extensive injunctive relief as well. The other regulator that I'll mention briefly, and I think we can then wrap it up to move on, is there are the Gramm-Leach-Bliley regulations. And so this, of course, covers all financial institutions. And there are a variety of regulators that have power in this space. So, for example, banks are regulated by the Federal Reserve and the OCC. Your registered advisors, broker-dealers are regulated by the SEC. Insurance companies by the state regulators. And here, each of these regulators was charged with implementing a regulation that these companies have to follow in the financial space. And the actual regulations vary a bit. Ultimately, what they say is companies have to have reasonable and appropriate controls in place. This happened a number of years ago, but to date we haven't seen a lot of actual enforcement activity in the space. The one agency that we're starting to see some movement from, in addition to the FTC, which has, consistent with its FTC Act power, consistently looked into this, is the SEC is getting more active. So in addition to bringing a couple of enforcement actions in the past couple of years, they have also had a number of other activities that just, I think, signal their willingness to be more engaged in the space. Those activities relate both to guidance they've provided on disclosures. They've also conducted a series of cybersecurity sweeps, you might have heard them referred to as, which has been in the past couple of years. They've gone and looked at a number of the agencies that they have jurisdiction over and really just conducted audits, you might say. There haven't been enforcement proceedings that have come out of those, but a lot of people are viewing that as a sign to the industry that they are to come. So to pay attention now. They've published the things that they look at, which again, many are viewing as a guide to the industry. If you're in their space, go and look at what they're assessing when they're doing these reviews, and ask yourselves, how would we fare if we were faced with a similar assessment?
Thank you, Michelle. Just to sort of one impression that I get from what you're saying is that, generally speaking, certainly until your comments about more recent developments, the liability has arisen after an incident. In other words, it hasn't been beforehand, and that where it has arisen more recently is through these audits that are very industry specific. And that's where you think that that's the trend that you see continue to happen.
Right, and the other trend that I'd highlight, particularly with the FTC, is that they seem to be moving away just from companies that have suffered data security breaches into a broadened jurisdiction that looks both at what I would call product developers. So a good example of that is, there was the Oracle case in this past year where, Oracle develops Java software. They're not a company that through Java is themselves collecting personal information, but they said that they were making deceptive statements and the product itself was putting customers at risk. Similarly, another case that caught people's attention, which opens up a whole new array of entities to FTC jurisdiction, was the Henry Sheen case. There what happened is there's a company called Henry Sheen that made an encryption product. They called it an encryption product. The FTC disagreed that it actually provided industry-level encryption, and they provided these systems to dental offices. And the FTC's assertion was, even though there was no evidence that any incident happened, that any information was exposed, that this was misleading because they were being deceptive about the truth of their security controls and putting the information at risk for these dental agencies that were collecting it for the consumers. So the FTC in particular has gone beyond simply waiting for a breach to happen. Separately, they are looking at service providers and not just saying, and so the distinction there is it might be, in one of the cases, GMR Translation, a company was contracting out certain translation services. The person they were contracting the work to had inadequate security controls, and the FTC pinned that on the original company. So it said, you are not, even though you yourself weren't breached, you didn't have adequate controls in place to be overseeing your service provider. So that's another area where we're seeing expansion in potential liability.
And how do these things, these sort of before incident interventions by the FTC, how does the FTC decide what to pursue, and where does it get the signals as to where to act and where to enforce before a breach?
Right. So a lot of it is, they're just looking at the information that's available in the market. Another trend that highlights is they've recently been looking into, for example, companies like the Oracle Java case that have vulnerabilities. And so they're reviewing databases in terms of, what the risks are, where it is. They're looking at news that people are reporting. And separately, there are businesses that, because they think in their interest, are the FTC's friends in terms of saying, hey, we're out there doing our own, they might call it ethical hacking, I don't know what they call it, but they're discovering vulnerabilities and letting the FTC know that they exist.
So that's one form of government cooperating with the government?
I guess so.
Being an informant? Well, we'll ask about some more benign cooperations. Yes? So just let me, for the purpose of the recording, the question is about can you comment on the developing standard of care? Do you mean just at the FTC or more generally? Okay. Right.
And I think, unfortunately, that's been one of the most frustrating things for business out there, is that there is no clear legal standard of care. The language that you see in all these cases is the vague, reasonable security controls, and in part because, on the consumer side and the regulator side, we're not seeing cases that are fully litigated. So there's not a body of case law that's developed that essentially says, okay, if you do this, that's reasonable. The few state statutes that have been passed to date, again, they just use that general terminology, so it's unclear. I think there are signals, so tea leaves that companies can read. For example, in the FTC and the payment card space, they seem to say, essentially, with PCI compliance, the signal there is they're not quite willing to say it's sufficient, but through some certain settlements, they've endorsed it as at least being pretty close. They recently had a news release on their views on NIST, which essentially, again, they were very careful to stop short of saying NIST is good enough if you go through the steps of the framework, but they basically said it's consistent with what we look at as a regulator. So I think, the advice that we often give, depending on the industry, is if nothing else, you have great defenses if you can look at what's your closest industry standard and comply with that. And the issue there is that many of these cases, too, they're negotiated behind closed doors. And if you can convince a regulator that you're at least a very, very close case, they may decide that they're better off spending their time elsewhere. So we do encourage companies to basically, find out what that industry standard is. Like I mentioned, if you're in the SEC jurisdiction space, it'd be a great idea to take a look at their checklist they've been using for the cyber sweeps and asking yourself, if they came in and asked me these questions, would I be able to turn around and say, yes, I have this in place, yes, I have that in place. But unfortunately, there is no single nice and easy checklist that companies can use at this point.
We might later on also, when we're talking about cyber risk insurance, we can talk about the standards, the checklists that underwriters use or that insurance companies use in pricing the risks and the premium. So let's turn to government collaboration or cooperation or interaction. And we're fortunate to have M.K. Palmore from the FBI office in San Francisco. And could you give us a little outline of generally about federal aid and state agencies and how they divide jurisdictions a little bit, and particularly about the FBI's role?
Sure.
Thank you.
Good morning, everyone. So I don't know about you, but Cybersecurity Month has been very busy for me. So this probably represents maybe my 10th engagement this month talking about this very important issue. So let me give you a bottom line up front. What does it mean to involve the FBI in a potential breach investigation? Because I know that that's a question that weighs heavy on you and your general counsels as you try and determine whether or not you even want to notify the FBI about a breach. So the FBI has essentially four objectives in any one particular breach investigation. The first of which is that we are always interested in defining attribution, and we're actually quite good at it. We have an ability, once given the proper amount of information, to determine who's on the other end of the keyboard. In other words, who executed your breach, who's responsible for it, and we're pretty good at, again, when we have the materials available to us, identifying in a post-mortem how the breach occurred and essentially how you then may need to go about shoring up your defenses. So attribution is key for us. Second, if we are unable to define attribution, we are very interested in TTPs, indicators of compromise, other technical information related to the breach that will allow us to then feed that information into the U.S. intelligence cycle, because there are a litany of government agencies engaged in the cybersecurity mission and fight to varying degrees. You will almost never see anyone at your doorstep except for the FBI, Secret Service, or DHS in that regard, though, because the three agencies that I just outlined have some piece of the investigative responsibility. Most closely related are ourselves and the Secret Service, although they have sort of outlined for themselves responsibility mostly as it relates to the financial sector, credit card data information, and issues related to the financial sector. So you'll see them plugged in through their Electronics Crimes Task Force in that capacity. We share those responsibilities with them in that regard, and we also essentially cover everything else as it relates to breach investigations. The DHS, most recently through PPD 41, was assigned responsibility for national infrastructure, and so While I don't see on your agenda that you're going to get into any in-depth discussions about infrastructure, SCADA systems, and issues related to those types of platforms, DHS through the NKIC takes the lead on that. And so just from that short description, you can see that everybody sort of has a lane, and although it's not explicitly defined in some instances, in other cases it is. And so that brings me to the topic of national security intrusions, which are topical. It's in the news today, and oftentimes there's probably someone in this room whose company has been approached or met their first FBI agent because we were notifying you about bad stuff going on in your networks by an FBI agent who was providing that information to you. And so the FBI does have primacy as it relates to national security intrusion investigations. Again, all of which is to define attribution, provide information to the U.S. intel cycle. Thirdly, we are uniquely interested in the postmortem in terms of helping you change your security posture. We have found in many, many instances that depending on the quality is not the right word, depending on the resilience of your response section, your internal folks, sometimes that you may find yourself assuming that you've eradicated the threat actors and gotten them out of your system, only to find months later that you didn't quite do enough and that they still happen to be present in your system. Bringing us on board early, in most instances, in terms of breaches, will help you define whether or not you've done everything that you need to do, because believe me, once we're brought into the loop, we bring extra information to the table that your teams are not likely privy to, especially as it relates to national security breaches and intrusions. Oftentimes what we find ourselves in need of doing is providing classified briefings to various persons within your company structure who we give essentially a one-day read-in for classified matters, and we help to sort of fill in that intelligence picture that you may or may not have available to you. So that brings me to the next issue as it relates to attribution, of course. Getting our hands on folks, getting them into the U.S. justice system. Another reason why the FBI can be helpful to you. A lot of the threat actors are in our country, within the borders of the United States, but most are not, to be quite frankly. We're finding more and more threat actors operating outside of the borders of the United States. And our ability, once we've defined who they are, our ability to actually put hands on them and get them into the U.S. justice system varies from country to country. Now, while the FBI chiefly operates domestically, we do have we operate in over 62 cities throughout the world, and part of the reason that we do that is, one, for direct cooperation with our law enforcement partners in the foreign countries that we operate in, and then secondarily, we have recently, within the past 5 years, begun to push out cyber-specific special agents who operate in those cities because there are certain cities around the globe and countries where we have an interest in mitigating the cyber threat or increasing our connectivity to companies and industries there in those countries where it might be helpful to us in terms of identifying and clearing up the intelligence picture. And so oftentimes what you'll find in your internal investigations is that your ability to impact or figure out what's going on may stop at our borders. We have the ability to extend that information for you and, again, act outside of the borders of the United States in cooperation with host governments to help fill in an intelligence picture that you likely do not have available to you. And so I hit on 2 points pretty hard. The third point, again, was helping you increase your posture by, again, bringing in and filling in some of this intel information that you might not have available to you. And then, quite honestly, the fourth thing is a responsibility to increase awareness on this topic, which is what I spend quite a bit of my time doing. So let me talk quickly about what that looks like for you in a pre-breach environment. Depending on where you are, and then certainly if your companies are in this region, we will come to your companies and speak with C-suite level personnel or your information security professionals or the board of directors, whomever it is that you think may provide the greatest impact in terms of identifying and creating some kind of parameters as to what we see the cyber threat landscape and how it looks. we see quite a bit more than most, but you have a snapshot of that picture as well. And so what we typically are able to do, and I've had many CISOs comment to me after these talks, is that they're telling you these same things, but for some reason when you hear it from us, it has a deeper impact on you, and it may loosen up the purse strings a little bit so that you guys start to spend money on these issues. So we will come in varying capacities, either myself, members of my supervisory team, agents within our cadre that have a specialty in a particular group will come and sit down and have candid conversations with you about what the landscape looks like and what steps you may want to take in order to better increase your security posture. We also recommend quite a few things, actually, that I heard talked about in this last panel. I'll only emphasize one of them, though, because I know that you're going to be doing an exercise later today. The tabletop exercise. What we have found is that companies that engage in practice as it relates to responding to breaches are infinitely better positioned to get themselves whole again as opposed to companies that do not conduct these practices. You will find in an actual breach that there are decisions that need to be made as it relates to business operations, legal issues, technical issues, and you do not want to be making those decisions for the very first time when you are in the midst of a breach, especially one if you think about sort of all the planets aligning and it being the worst of all possible situations. A breach where lots of user data is now on the web, the media knows about it, and so you're under pressure to respond and or issue a statement in some way, shape, or form. And the third vector or parameter that I'll outline is that, typically in most of these breaches, you guys are finding out about it late. And so if we are 6 months into a breach and you're just now responding to it, media is on board, and you're really, really trying to figure out how to get yourselves whole again, you don't want to be, again, making those core decisions about how you're going to get across or through this particular situation. You don't want that to be the first time that you're doing it. So the exercise allows you to do that in a comfortable environment, and in some instances, we will actually help participate in those tabletop exercises. We'll have an agent sit through and let you know how the FBI would engage with you during those particular times when you're in the midst of a breach investigation. And a lot of companies have found that kind of input helpful to them.
I would briefly underscore that point from the legal liability side as well. One of the things I didn't really get into, but is true, is that sometimes these decisions that I mentioned on whether cases get dismissed early can depend in large part on how the company responds to the breach, what they're saying, what actions they're taking. And we've definitely seen that when people are considering that for the very first time in that crisis moment, sometimes decisions get made that had they thought about them in advance and gone through such an exercise, they might have made decisions that better position them, both for all the issues MK was talking about and the legal liability side as well. So that's another point that I will be strongly supporting that we've heard many times today.
Yeah. I mean, hopefully that all makes sense to you guys. I know that when you think about an exercise like that, it can be disruptive to your business process. I mean, everyone's busy. You don't want to take the time out, but you can knock a constructive review out in about a day, allow someone else to do the planning, and then just bring in the principals on the day of the exercise, and then walk through the machinations as to how you're going to get from A to Z in a particular breach. And believe me, there will be questions that come up that you had not thought of, that you've never engaged in, and you will find yourself answering and thinking about things that are not typically on your plate as a business executive. So again, I can't reemphasize that enough, and thanks for the feedback. Do an exercise. So what happens if you're on the bad end of a breach and you have consulted with your general counsel and you've decided that now you want to notify the FBI because you want to bring us in? What does that look like?
By the way, just let me interrupt.
Sure.
When a company contacts you, do you suggest to them that they get in touch with their counsel first before?
Believe me, they won't. They know better. They won't call us without call counsel.
Okay.
They won't even call us. That's a. I will tell you from a personal standpoint. I took over this particular position right on the heels of the Snowden revelations, and as I assembled my team and started to talk about the way forward and what we were going to do, the first thing they told me, boss, our relationships used to be great, and now they're crap. The companies won't even talk to us. So companies will not engage with us unless their general counsels have given them permission to do so, and that's fine. Extra bodies at the table is always good.
I also support that.
Before we move on to the report, I have a question for both of you. Others I know probably know the answers, but I don't. But when you do a tabletop, or when you do an audit, how much of that is discoverable? So say you do a tabletop, you find out all these holes in your infrastructure. That's discoverable later on?
Yeah, so
That's a great question.
That's not part of an investigation for us. It may be if, quite frankly, if an industry knows to even ask for that kind of material, if they know to ask for it, it may be a point of discovery. But having conducted it means a lot. It means that you have taken an affirmative step in identifying what your gaps and vulnerabilities may be in terms of the planning cycle and process. And more importantly, so there's two phases of the tabletop. There's three. There's planning, there's the actual execution, and then there's what you do with that information post-exercise, right? It's not enough to have done those first two steps and then to have that packet sitting on sitting on a shelf somewhere.
Right.
Hopefully your CISOs and folks will take that information in a postmortem and then talk about what changes you need to make or what things you can do to better shore up your defenses and your business processes and your reaction to a particular event. I doubt very seriously, and I welcome input from the rest of the panel, that conducting a tabletop exercise will ever hurt you. It's not something that will be used against you. It can only help you.
Yeah, and I think there's a distinction between the tabletop exercise we're talking about and the audit. I have to say, as a defense lawyer, when I heard Professor Grunfest talking about get in there and have people perform the audits, had a little bit of the freeze there, because I have had situations in litigation where, it's the double-edged sword. So in that situation, you never know how to improve unless you're conducting these assessments. I have seen assessment reports be some of the absolute worst documents for a company in a litigation context, but that's largely, to your point, because actions weren't taken. The problem, I would say, there is that it's not at all uncommon to, you're hiring a third-party expert to come in, and one, they want to cover themselves from potential liability and show their value. So what you're going to get back is a list of 120 things to do that goes far beyond what a company is actually going to do. So one of the things that we actually counsel that's not actually just for the discovery point, but it has the discovery point advantage, is that because of all the legal liabilities that are related to this area, it is perfectly acceptable and makes sense, and there's a legal purpose to do these assessments under the direction of counsel and have legal advice be flowing from that. If you take the time to set it up through that arrangement, you at least have an argument that the materials are not discoverable in the result of litigation. There hasn't been a lot of litigation, but in the few cases we've done, we've actually had good results in not having to disclose those reports. And I think it is helpful just because from the legal perspective, the lawyers do have a separate bent from the consultants, and based on the same findings, can provide that extra layer of legal advice.
Michelle, can you also address the post-incident conversation with the FBI and any concerns about discoverability?
Sure. So I think it's just a matter of being careful how you do it. So in general, facts aren't privileged. A lot of people conduct their post-investigations under privilege. What you can't do is simply take your privileged experts' information, writings that they've prepared in connection with what they're doing for counsel, and hand them over to MK and his colleagues, because you're going to waive the privilege for that. You also have to be careful because any documents that you do provide, if you have a regulatory investigation, that's going to be right on there at the top of the request list is any documents that you've provided to government agencies. But that doesn't have to stop the flow of information. A lot of times, during a meeting, you could sit down and provide facts. It might be that there are certain, non-controversial facts about the breach. They might ask for IP lists, something else that your lawyers are going to say, yeah, those are undisputed facts. We're not overly concerned. Go ahead, hand those over. I think the main point is just being careful in this context that you're working with your counsel in determining that you're not, one, waiving privilege, or two, handing over documents that you're just going to have to turn over to the regulators that, while they may be helpful, in the one context could hurt you in another. So in general, we've been able to work through this in a way that I think gets what I would call sometimes the helpful government agencies, the information that they need, without putting you in a bad position in terms of the agencies that are there to investigate you, as opposed to investigating the criminals that perpetrated the attack.
Thank you. Isn't it nice to know you're a helpful government agency?
Absolutely.
One of those?
I always say that. We're here to help.
Go ahead.
Hey, so let me hit a couple of highlights of what the FBI is not and what we do not do in the post-breach environment. First, to pivot off of the last point that Michelle made, the FBI are not regulators. Do not go into a breach scenario believing that if you notify the FBI and that if we come to help you conduct an investigation, that all of a sudden you will be descended upon by a litany of regulators as we uncover information that puts your preparation in a bad light. That's not what we do. We are there to help you figure out how you got intruded upon, figure out who was responsible for it, get that person in a courtroom and get them prosecuted. We are not regulators. If you find yourself being investigated by regulatory agencies post-breach, obviously we have a responsibility to cooperate with them, but don't get the impression that we will bring them to the table and that will sort of unleash a litany of intrusive investigations that will put you in a bad way. Secondly, a couple of...
Can you
yes.
Specify, so from a confidentiality standpoint, what is stipulated that you have to provide because you were there versus what you're able to retain as privacy, and not just with regulators, but, for example, when there's congressional type interest, as there has been in a number of these, even the privilege does not apply to Congress in the same way. So can you talk about what your lanes are in terms of what you're allowed to protect?
Yeah, so I'll answer that question this way. There are virtually no stipulations that I'm aware of that require the FBI to turn over investigative information to regulatory agencies. If we do, it's done in an extremely collaborative way, and it's done in a way that will, one, the victim company is made well aware of what information we may be in a position to turn over to them. And we may decide collectively as a group that a better way for the regulatory agency to get that information may be for them to serve their own legal process and get it done in a manner that keeps their investigation completely separate from the FBI investigation. We do not go into our investigations assuming that, if the FTC or SEC swoop down in addition to us, that we are going to completely share the information that we have available to us as a matter of the investigative breach investigation that we're engaged in, because we see those investigations as distinctly different from the investigation that they're engaged in. Media. We don't go to the media. Or, quite honestly, we're probably as bad as any government agency in terms of our engagements with the media. There is a misperception by victim companies that somehow notifying or bringing in the FBI will result in the media being notified about their situation. Quite honestly, I will tell you the same thing that I tell most private sector entities. If your company has been the victim of a breach and the media finds out about it, the information likely came from inside of your company. We do not, as a matter of course, provide that kind of information to the media. What we will do, in conjunction with you and your company, is that if you've made the determination that you need to make a statement, in other words, more instances than not, General Counsel has decided that the company needs to make a statement, we will release something in conjunction with that statement. But as you've seen from the press, our statements tend to be very sort of flat and not filled with a ton of information, other than to say that we're assisting or cooperating with the company in terms of conducting the investigation. So please internally dispel that myth or rumor. And then lastly, most of you will engage third-party vendors as it relates to making yourself whole. We work hand in hand with those third-party vendors. They are used to working with us. We are used to working with them. And again, you still control the delivery of information in that regard. Don't assume that by us working with that third-party vendor that we're automatically going to have access to information. There's still a requirement. The vendor works for you. They still make sure that the information that they share with us is information that you've agreed to share with the FBI. And so it's a very, very collaborative process. And we work hand in hand with those third-party vendors. And I'll leave it at that. I'm sure there's lots of questions.
Thank you, MK. Teresa, you're in a position to offer us insights as both having been in government with the NSA and now outside. And so at the same time, you can say, well, what is government trying to do? What are their priorities? And as an outsider, you can observe and tell us, is it working?
Well, I've only been an outsider
all in less than 10 minutes.
Yeah, okay. I've only been an outsider for a short period of time. But I thought that what I wanted to do was talk to you a little bit about national policy in this space. And of course, the national policy is really driven by the administration. And so we need to start by understanding what the priorities are for this administration when it comes to cybersecurity. And there are 5 priorities, the first being protecting our critical infrastructures. And Suzanne Spalding, who's part of the Department of Homeland Security, spoke eloquently about this morning, and that's under her responsibility. The second is improving our ability to identify and report on these cyber incidents. And part of that, key aspect of that, is this sharing of indicators between the public and the private sector. And the third is engaging our international partners. We've always talked about cyberspace having no geographical boundaries and engaging with our international partners, largely with the focus being to promote internet freedom. 2 aspects of that, setting the standard for developing the international norms of behavior in cyberspace. And the second one is the collaboration to get to this cybercrime. And I think MK can talk at length about the modernization of the mutual legal assistance treaty that they've been working on. The fourth priority is the securing federal networks. And if you weren't convinced of that before the OPM attack, I think that was enough to convince all of us. And the fifth one is the shaping the future cyber environment. 2 points on that. The first being trying to build a cyber-savvy workforce for the future. How many of you think that you have enough professionals that are very versed in cybersecurity and you're comfortable that you've got that kind of talent? Yeah, so this is a common theme, that we're really lacking enough professionals in the space, in the cybersecurity space, that you can really all be comfortable that you're well defended. But the second piece of that, and this has to do with you as well, is this prioritizing research and development, technology transition, and harnessing the private sector for the innovation that's going on there while ensuring the protection of privacy and civil liberties. So those are the 5 priorities, and from that has been multiple policies that have been issued, not just from the administration, but also from the multiple regulatory agencies that cut across the government, both at the federal level and at the state level. It's worth me sharing with you this definition of cybersecurity policy that the federal government uses because it's so broad. So just bear with me. I just want to share this with you. Take 1 minute. Define cybersecurity policy as strategy, policy, and standards regarding security of operations in cyberspace, encompasses the full range of threat reduction, vulnerability reduction, deterrence, international engagement, incident response, resiliency, I'm only halfway through, and recovery policies and activities, including computer network operations, information assurance, law enforcement, diplomacy, military, and intelligence missions as they relate to the security and stability of the global infrastructure. So you can see that's a pretty broad definition, and it kind of gives you a little bit of understanding of why you're seeing so much policy start to emerge. And I know Michelle talked already about some of the agencies that are releasing policy in this space, but just to foot stomp a few more, the SEC, the FCC, Health and Human Services, FTC, the Consumer Finance Protection Bureau, state attorneys generals across the nation, and multiple other government agencies. What I've seen from those, a little bit that I have had paid attention to, there's a couple of key common themes. One being most of them come with regulation. And the second being, though, most of them are putting their policies out for your comment and your input before they finalize it. So to the question, George, of whether these policies are actually working or not, I think it clearly depends on what we use to measure them. But just a couple of examples of where I think we might be lacking in policy or we are not able to enforce policy effectively. The first goes, again, back to this information sharing between the public and the private sector. The government cannot protect us in this space alone. They need the private sector. Suzanne's point about 80% of the critical infrastructures are either owned or operated by the private sector. Department of Homeland Security's got great plans out there on all 16 critical infrastructures. Each one of them has a cybersecurity component that talks in depth about what needs to be done, but there's no mechanism or authority for them to enforce it, especially when the critical infrastructure is privately owned. The second is this lack of notable, I think, policy around U.S. government response action in cyberspace, and quite frankly, the simple definition of what a cyber attack is. And we've seen this play out in the DNC hack that's already been talked about at length, with the Russians attacking and being attributed, good job being that we are able to attribute those attacks. But where does the line get crossed? When nation states go beyond espionage, information sharing, information operations, doxing, intellectual property theft, even this idea of pre-positioning warfare capabilities, does that cross the line? And if so, how should we react to that? What should be our counteraction? The debate on the DNC hack has really been about, if we don't do anything, this inaction, then we're just giving these nation states a green light to go ahead and proceed and do more. The other side of the debate is you have to be very careful about escalating this, especially since a lot of folks feel like here in the U.S. we sort of live in a glass house when it comes to cybersecurity. So, and I think the government has already come out publicly and stated that there will be counteraction. It will be proportional. It'll be at a time of our choosing, and the public may not know about it. But I do think that there needs to be some concept of, can companies have the ability to protect themselves? How far can they go? What about the hack back? And what kind of policy does the U.S. have in this space? So I still think that's a little bit lacking. The third one is we already talked about in terms of the Dyn attack. This originated with an attack on a very well-known security expert, Brian Krebs, who has a website called Krebs on Security. What he does is he tries to uncover these criminal acts. As a result of that, he was attacked with this massive DDoS attack using the Mirai malware that was then published on the open web. The question I want to get at is, and some of this has already been discussed earlier today, is should these developers of these Internet of Things devices be held in some way accountable and responsible for providing security to these devices? And furthermore, if you go down that path, even with in the critical infrastructures, for example, the industrial control systems, should the developers and manufacturers and capability providers in that space be held to some standard in terms of providing security? And that, I think, we have not clearly decided or defined, if you will, to that point. So that's still open. And then my final example was just on the international front. How many of you are familiar with the Wassenaar arrangement? You might have heard about this if you're in the cybersecurity business. The Wassenaar arrangement is on export controls, largely for conventional arms and dual-use goods and technologies. And the U.S. and the Western countries really had a push to put operating systems, software, and network exploits to be included in these export controls. Now, network exploits, as we know, are dual use. We use them for pen testing in cybersecurity as well as they can be used against you for attacks. So as a result of just the outcry of the cybersecurity industry here in the U.S., that is going to result in the U.S. going back to the drawing table, if you will, this is a big deal, to go back to an international body like that and renegotiate the agreement. That's a huge deal. My point there is your voice matters, and the more you weigh in on these policies and the more that you actually give feedback, I think that can make a difference. So my bottom line is, yeah, the breaches and attacks are continuing despite the policies that we have in place and the new and emerging policies that are constantly being developed. Are we getting better? I think we're doing much better at attribution, as MK has already talked about. And I'm excited about the cybersecurity market. I think a lot of the technologies in the cybersecurity market are going to really give us a leg up. However, when you talk about things like artificial intelligence and automation and robotics as it applies to cybersecurity, the policy space gets a lot more difficult. But policy alone, as we've already talked about, is not going to solve this problem. You have to combine the policy with the people and the technology and the intelligence, I think, to get to a better state of security.
Thank you very much. Thanks, Teresa. Well, the final topic that we'd like to cover on this panel is how the market is dealing with risk in terms of insurance. And so I'd like to ask Lauri to sort of give us a little outline of where it's come over the last 5 years and where we are in terms of coverage and underwriting and so on.
Sure. And, we talked about me sort of batting cleanup on this panel to be able to respond and reassure you that a lot of what we've talked about in these first 2 panels, even so far, is being addressed in the insurance markets. There are solutions that address the exposures and the increased cost, not only of the direct impact to business potentially, but the legal liability, the government investigations arising out of cyber events, and going beyond data breach. I mean, I'm sure there are a lot of companies sitting in this room that say, I don't have PII. Other than my employee data, I'm not a consumer-facing business. Does all this stuff really matter to me? And there are a lot of different cyber exposures that go beyond the consumer data breaches that we hear about all the time. And I think when Suzanne opened the conference this morning, and her advice was that companies need to take a step back and think about what would have the most impact on your business. That's exactly the same advice we give our customers, and that's how we talk to our clients about thinking about their cyber risk. You have to actually think about cyber risk as a peril, and what are the different ways that risk can impact our business. If your business is manufacturing and it's industrial control systems, and we're worried about our manufacturing line shutting down, that's a business interruption risk. If we're worried about it causing a thermostat to shut down and a piece of machinery to overheat and explode and cause property damage, that's a property risk, and your property insurance policies should cover that exposure. If you're in medical devices and a hacker is able to get into the pacemaker that you manufacture and cause injury to the individuals that are using that device, that's a product's liability exposure. The bodily injury arising out of that should be addressed by your product's policy. So first of all, this idea of cyber insurance, not everything that stems from a computer results in coverage under a brand new policy. It is important, though, to be looking at all of those policies that you have in relation to those specific exposures and make sure that they're not adding new exclusions, that they're not being modified in a way. Because there's some insurers that are definitely getting nervous about some of these exposures, and they are underwriting for it, and they're asking questions about how you're, if from an Internet of Things perspective, is there a software update to your product? Are you potentially going to be liable for the resulting damages from events like the Dyn attack last week? So thinking about cyber as a peril and looking at all of your insurance is important. But the other thing I'd caution you is not to just rely on standard insurance, and specifically depending on the types of risks you have related to data breach. We spend a lot of time talking about data breach in this industry because it's a very expensive problem. For companies that are consumer-facing, Target, in their final Q, where they published some information about their data breach, said it cost them $291 million to respond to that breach. And the cost there is, Michelle said the settlement of the consumer class action, that piece of it was like $17 million of that. So the rest of those costs came from other sources, dealing with the issuing banks and the credit cards, dealing with the cost of notifying their customers and offering them credit monitoring, the cost of the forensics and all of the technology infrastructure that went into that. So the costs are widespread and come from a bunch of different categories. And this is where the evolution has been in the new products that have developed in the insurance industry to respond to those specific exposures. So the policies that are referred to in the industry as a cyber insurance policy are specifically designed to cover network security and privacy events, and cover both the first party and the third party exposures arising out of that. So first party, meaning direct costs that your business incurs as a result of those attacks, things like forensics, things like notifying people. Then on the flip side, the liability arising out of that, the consumer lawsuits, the regulatory investigations, even in this world, the fines and penalties that government agencies might levy, or in the payment card industry, the assessments from the issuing banks and the payment card industry related to the breach, all can be covered under a cyber insurance policy. So thinking about that coverage, if it's appropriate to your business, if you have consumer data, then you have to think about what all those different buckets could be. How many records could we potentially be exposed? And you can do some simple math about what some of those things might cost to help you come at what's a reasonable limit. The other area of coverage that is getting a lot of attention now is business interruption arising out of a cyber event. So just like in your property world, where you have a property business interruption clause that if your business burns down, you get the loss of profits and extra expenses that you incur can be paid by your insurance. You can have that if your network is attacked by a denial of service, as we saw with Dine last week, or some malware that shuts down your network and you can't interact with your customers. That loss of profit that you have from that event can be covered in a cyber insurance policy. And although this is not as widely purchased right now, it's an add-on component that is widely available but not always taken as an option. People have tended to think, it'll never work, it'll never apply to me because the waiting periods are too long. Typically, they say you have to be down for 8 to 12 hours, or your business has to be measurably interrupted for 8 to 12 hours before the coverage kicks in. Well, I can tell you I have a customer who this summer had an event that lasted, their network was down about 12 hours, but it caused a material interruption in their business that lasted several days. I think ultimately their cyber insurance program is going to respond to the tune of $50 to $75 million in reimbursing them for their lost profits and extra expenses associated with that event. So there are different ways to think about it, and it really depends on your specific business. To get back to the original point, which is that you need to understand how a cyber event can impact your business and what the different insurance ramifications of that might be. So that's kind of a broad overview of where insurance sits right now. It is constantly changing. There are new insurers offering new solutions constantly. Some of them are just sort of repackaging existing solutions and combining them together to respond to different needs. Definitely in the property context, we're seeing a lot of insurers saying, well, let's sell you a separate property cyber policy. We'd really argue against that approach. I think to the extent that some of the existing products do a very good job with this exposure, but you really just need to understand what you have before you move forward.
Thanks, Lauri. Joe mentioned and Joe Grunfus mentioned, Michelle commented on the possibility of inviting your counterparties in to do an audit and do so on. And, there's some cautions there that Michelle mentioned. What about your insurer in the underwriting process? Does that provide you with any information? And after you do get the insurance policy, what is the relationship with the insurer that follows that?
Getting cyber insurance is not a simple process. I will caution you on that the amount of information they require, it's not an either or. It's not, should we put some security in place or should we get cyber insurance? You're going to have to demonstrate that you've taken some thought with security in protecting your network and managing risk in your business.
Significantly in the past few years.
Yeah, absolutely. And so that it's going to go hand in hand. If you don't encrypt any sensitive data, you're not going to get coverage for breaches related to encryption of sensitive data, or you're going to have much more restrictive coverage than you otherwise would. And there are also all sorts of solutions that the insurers are offering, particularly to smaller customers, that make a lot of sense of providing some risk management and some tools that you get along with these policies to get audits of your network, or to have shunning technology that sits outside your network, or services that will advise you of traffic that's going in and out of your network that's coming from known IP addresses where there have been problems. So there are a lot of things that insurers are trying to do to provide some risk management support alongside these policies. But I think there's a lot to come in that front.
I think we have time for a couple of questions. Yeah.
Is that kind of new? Because the number of companies that I've worked with in trying to provide cybersecurity to, they never seem to get paid out on the insurance. So the vulnerability testing and all that is happening now to go build policies. Is that fairly new? Because like a year ago, getting paid on insurance was almost impossible on cyber insurance.
Well,
Sorry, the question is, have things changed in terms of the ability to get paid out of insurance?
I think what's happened in the insurance industry is there's been a lot of there've been a lot of cases of people trying to use older insurance policies that weren't designed for these exposures to get coverage for cyber risk. So a lot of the litigation out there that says that insurance doesn't cover cyber risk is because that's related to general liability policies that weren't designed to cover this exposure. They certainly didn't cover the first-party expenses. They only ever covered the potential liability arising out of it, so things like the cost of forensic IT work to come in and assess the scope of the loss would never have been covered in those cases. And those policies have all evolved to where they now all clearly exclude data breach and privacy events from general liability. If you have that exposure, you need to be purchasing a separate cyber policy that's designed to cover network security and privacy. So I think that's the first part of that. We've seen these policies actually perform really well. I mean, and the scope of in data breach in particular, from discovering the loss all the way through to paying the fines and penalties at the end, is actually really clearly spelled out in these policies. So I think the bigger problem has been people using the wrong insurance products to try and solve this.
Yes.
Any guidance on contracts with vendors and flow down of liability? So if your vendor, your third party, your subcontractor has a breach.
Now this. Questions about the guidance on the risk allocation between the vendors and their clients when the breach comes through a vendor, and how does the insurance work and how does the contract tend to work, right, in assigning liability?
Yeah, I could start on that, and Michelle might have something to add from the contractual piece. The insurance policies are, again, well designed to address this from a breach perspective. So if you have the direct relationship with the consumer, and there's a breach of that data, you're covered regardless of where the breach happens. If it happens on a vendor's network, if it was a vendor's fault, if it was on your own network, if it was an employee error versus a malicious attack, even, frankly, paper files, or improper disposal of documents or something can cause a breach, would trigger coverage under a cyber policy. That's not the case in the business interruption context, and this is a really important distinction in these policies. Because most policies will only cover your loss of profits and extra expenses, that network business interruption component, when the attack is on your own network. So something like what happened with Dyn last week that takes down multiple companies, that's exactly what the insurance industry is nervous about, right? If AWS or Google is the source of the problem, and virtually everybody they insure is relying on those one of those two customers, then that could cause them to have losses on hundreds or thousands of policies. So insurers are being much more careful in the business interruption context about how much contingent business interruption they're offering. So the idea of a third-party vendor failing and causing the outage, you can get that coverage, but it's something that you have to be specifically seeking to know that you have it.
And I think on the liability side, the vendor component comes in two places. One, there's the vendors that you're either sharing your customers or other information with, or you're giving them access to your network for some reason, which I would separate from the vendors that you're buying products from that might impact your cybersecurity. With the former, I think the main advice is you should be thinking about that in your contracts, especially both in terms of private litigation and regulators. They're assuming that if you are sharing information with third-party vendors, that you have sufficient controls in place, which starts with the contract, So your contract should, at minimum, be imposing some minimum level of information security. I mean, the norm is to make it similar to what you're requiring of your own company. We're seeing, especially depending on the information, there can be audit rights. There should be some ability for you. And that's what we're seeing from the regulators. This is not necessarily enough just to say, okay, we have it in a contract, we're covered, especially if real sensitive information is at issue. They expect you to be taking that next step and doing some diligence, asking those questions. So I think the main thing there is just, one, do something, and also making sure that the contract covers a situation where there's a breach, that you're getting adequate notice, that there are provisions that you can be getting the information that you need to be responding to the risk that you're facing and for your customers. It's a little bit more difficult on the product side. I think that's been some of the struggles for companies that have suffered breaches, where they'd love to turn it around and say, it's not my fault. I bought this product. I was assured to be safe, and it's because the product had a vulnerability. I think there the contractual trend has been in favor of the product suppliers. We're seeing some more pushback on that, but I think it's still a tough negotiating position for many companies there. But we're seeing more movement.
But the Henry Shea case that you mentioned before, fall into
Yep.
that?
So that's a situation where actually the issue there is that they might have been safe from their contracts with the dental offices, but the FTC said, we don't care about your contracts, we think it's your fault. So that's an issue that if you're on the product side, a lot of people have historically thought, we're safe, we have these great contracts in place, so there's going to be no liability as to our business partners, but regulators don't care. Regulators are going to say, okay, who do I think is the party ultimately responsible for putting this information at risk? Doesn't matter to them. So that does relate to that context, exactly. Yep.
Okay, so on your behalf, I'd like to thank the panelists for sharing their time and expertise with us. Thank you.